The judge tells us to go pick a jury, and now I go into the jury room with my adversary. Why is the most worrisome part of jury selection the fact that there may be some potential jurors in there who are prejudiced? Why is that a worrisome thing for me as the attorney who's trying the case? You want to know the answer? Come join me as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney practicing law in the state of New York. I'll tell you why prejudice is so worrisome for me as an attorney who represents injured victims. It's because when you ask a potential juror if they are prejudiced, they will always say, no, absolutely not. Nobody ever wants to acknowledge and admit that they may be biased or prejudiced. Now, what does prejudice really mean? It means that you are prejudging something, something you may have heard about, something you may have learned about. You may have heard only part of the story, and that prejudges you to listening to other sets of facts. And now, the biggest problem that attorneys have during the course of jury selection is that the potential jurors who are coming in to decide our client's case, they're not hooked up to lie detectors. We have the opportunity to ask them questions during jury selection to determine whether they are the right type of person to sit in judgment of our particular case. And we have to accept what they say. And just by talking to them, we have to get a gut feeling, a sense of whether or not they're being honest and truthful and open with us when they respond to our questions. Hey, Mrs. Jones, have you ever been in this situation before? You have? Terrific. Well, how did that make you feel? And now you have to judge for yourself during the course of discussing these issues with them, whether or not there's something in their background that might cause them to lean in favor of or against one side or the other. And if you think they are, then we have to do everything possible to try and get them off of this jury. Either they're going to excuse themselves and get them to recognize on their own that they're not the right fit for this jury, or we have to exercise one of our challenges. Now, what does that mean? It means we have the opportunity, 3 opportunities, to dismiss people for no reason whatsoever. We don't have to give our opponent a reason. And once we have used up those 3 reasons, now if there's somebody else who's still left on the jury who we believe is not appropriate, now we have to explain to our adversary why this person doesn't belong on this jury. And if my adversary still doesn't agree, then we have to take it up with the judge. That's known as a challenge for cause. And now the judge will hear argument from the 2 attorneys about why we believe that the juror should not be sitting there. The defense will have an opportunity to say why this person should, and then ultimately the judge will decide whether or not to keep this person on as a juror. So why do I share this great information with you? I share it with you because prejudice is always present, and the idea is to try and identify it before we start the trial, to try and remove those people who are biased, but we can't always do that. That's because we have to rely on these people, these potential jurors, to tell us the correct information. You know, I recognize you watching this because you have questions or concerns about your own particular matter. Well, if your matter did happen here in New York and you're thinking about bringing a lawsuit for your own matter and you've got legal questions, what I encourage you to do is pick up the phone and call me. I can answer your legal questions. You know, this is something I do every single day and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, G-E-R-R-Y, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.